Good morning to everyone out west, and good afternoon to our friends out east. For those of you like us in the middle, thank you for spending your lunch with us. We have an excellent session of our monthly legal updates for Canadian employers series today. We are going to be looking back at pivotal moments in 2025 in order to stay ahead in 2026. My name is Craig Lawrence. I'm a partner in the Employment and Labor Group here in Toronto. I am joined today by four colleagues from across Canada in our National Employment and Labor Group. We have Jeff Bastian, who's a counsel in our Vancouver office, speaking on BC issues. We have Jennifer Thompson, my partner in the Calgary office, joining us to address Alberta. We have Camille Paradis-Loisel as a senior associate in our Montreal office to give us the Quebec perspective. And Larissa Workowicz, a senior associate in our Toronto office, is also joining us to give us a more national perspective on Canada-wide developments. But Larissa is going to talk about what's new at the national level. Larissa, over to you.
Great. Thank you very much, Craig. And so to start off our first webinar of 2026, let's look at what has happened at the federal level in 2025 and what that means for 2026. Now, regular listeners of our webinar series will remember in the What You Missed on Your Summer Vacation webinar, I had previewed that amendments to the Canada Labour Code would be coming into effect on December 12th, 2025. And those have indeed now come into effect. Now, specifically, the Canada Labour Code was amended to introduce a new leave related to pregnancy loss and to also introduce enhanced bereavement leave entitlements for employees. There is also a new leave entitlement that relates to placement of a child, i.e. through adoption or surrogacy. Though that leave is not yet in force, but will be coming into effect soon. And so just to start off, let's dig in deeper into each of these different anticipated changes. So starting first with the amendment on December 12th, 2025, the new leave of absence for pregnancy loss. If we go to the next slide, you'll see that this entitlement extends to employees where their pregnancy, the pregnancy of their spouse or common law partner, or the pregnancy of another person, for example, a surrogate, would have resulted in a child being born to that employee, and they would have been the legal parent. If any of those circumstances, unfortunately, does not end up resulting in a live birth, the employee is entitled to the new leave of absence that is now in effect. This provides employees with up to 8 weeks of unpaid leave in the event of that resulting in a stillbirth or in any other type of pregnancy loss up to 3 days. And the first 3 days of this pregnancy loss leave are paid if the employee has the common threshold of 3 months of consecutive service, as you see with a lot of leaves under the Canada Labour Code. This leave entitlement is available once per pregnancy. If we turn now to the next slide, the enhanced bereavement leave entitlements have also now come into effect as of the same date, December 12th. Now, anyone who here is a federal employer would know the current entitlement is 10 days of bereavement leave under the Canada Labour Code, with the first 3 days of those being paid if, you guessed it, you have 3 months or more of consecutive service with the employer. The amendments have now introduced an enhanced leave if the employee's child or the child of the employee's spouse or common law partner passes away. And in the unfortunate circumstance that happens, the employee is going to be entitled to take up to 8 weeks off for bereavement leave. That leave can be taken starting as early as the day on which the death occurs and ending 12 weeks after the later of the date of the funeral, burial, or memorial service for the passed away child. And now turning to the next slide, the last leave of absence amendment that is anticipated but has not yet come into force is the new leave for placement of a child. And this will support employees who are welcoming a child into their family through either adoption or surrogacy. Employees will be entitled to up to 16 weeks of unpaid leave to help them with managing the new responsibilities that come with the child coming into their care. And then, employees will have the right to return to their same or a comparable role if they do utilize this leave. Now, as I've said, this leave is not yet in effect. It is anticipated to be proclaimed into force sometime in 2026 to align with the amendments that are also being introduced to the employment insurance scheme, specifically in June of 2024. The Government of Canada had passed legislation introducing a 15-week shareable EI benefit for individuals who have received a child through adoption or surrogacy. And so the Canada Labour Code is going to be amended to align with those EI benefits. I just understand that right now steps are being taken to bring these amendments, both on the EI and the Canada Labour Code side, into force. But the messaging we have seen from the government is that this is something that will come into effect in 2026. In terms of next steps that stem from each of these three legislative amendments that I've gone over, I think it goes without saying that employers should take a look at their policies, they should take a look at their guidelines, whether internal or facing for their employees, and make sure that they've been updated to reflect these new entitlements. As for what we can expect coming soon, we do anticipate that other changes to the Canada Labour Code will probably be announced. The Labour program does have a plan for 2023 to 2025 that is really tailored around giving employees with more protections, more rights, particularly related to circumstances outside of the workplace. And so it's possible we'll see more announcements coming up, especially closer in time to the economic and fiscal update in the spring. And now, on a final note, if we turn to the last slide, some of you regular listeners might be thinking, but hey, what's happened to the federal right to disconnect legislation that was causing such a flurry in the media? You know, the one that the federal government had said was going to require you to put together a policy that set out the expectations around work-related communication outside of the workforce. Well, that's still not in force. We do not have a definitive timeline on when we can expect that significant amendment to come into effect. But that same regulatory program that the Labour program has that I've talked about for 2025 to 2027, it has been updated and it now references a 2026 coming into force date rather than a 2025 coming into force date. So it is something to keep an eye on for the upcoming year. Once this does come into force, employers will have a year to bring themselves into compliance by developing the required policy. And we do anticipate more information will be available through guidelines and other postings from the government once this is scheduled to come into force. So stay tuned to this webinar series and to the helpful blog that Craig has referenced for more information on that. And with that, I will now turn things back to Craig.
You know what? If your slides are up, Jen, then I think you're up.
Let's go for it. So thanks, Craig. So good morning, everybody from Calgary. I'm going to take you on a very quick whistle-stop tour of the Alberta 2025 employment law developments. And it will be quick because, as Craig said, we have only got 10 minutes each. So the first stop on this is human rights. And I'm pleased to report that it has been a decent year overall for employers in Alberta. Over the past few years, we've seen general damages awards go up quite substantially, with the highest award being $75,000 awarded in 2024. We've also seen those middle level awards increase quite a bit from kind of 15 to 20, now looking more like $30,000 to $40,000. We haven't seen that so much in 2025. They've been pretty stable, which is obviously positive. What I would say is we do expect that that won't last much longer, and that where there is opportunity for them to go up, and we fully expect that those general damages awards will continue to trend upwards. But at least we have had a bit of a reprieve in 2025. Then I just wanted to highlight two decent decisions that came out for employers this year. The first is well, it's an example that miracles can happen at the Alberta Employment Rights Tribunal, because the Human Rights Tribunal actually made a cost award against a complainant. Now, as most of you would know, costs usually aren't awarded in human rights. They just tend to fall where they fall. And so it's very unusual that a cost award has been made against a complainant. In Sherdunke and Paladin, the Human Rights Tribunal actually awarded $25,000 against the individual complainant. And I think this was a very fact-specific case, and that that justified that kind of award. It was a case where there were allegations of an abusive process, where the individual had failed to disclose relevant information and had hidden documentation that showed that the complaint was essentially frivolous and a sham. So it was a case where this was justified, but all the same, very positive to see that where the facts are right, that the tribunal will make those kinds of decisions. The second decision is Amy's and Lethbridge Family Services, and in this case, the employee was subject to 3 workplace investigations before then going off onto a leave of absence related to a disability. On their return, the employer terminated the employee's employment for just cause, and the employee tried to claim that this was discriminatory and linked to the leave of absence and the disability. The tribunal found that it wasn't discriminatory, that the employer did have grounds to terminate arising from those workplace investigations. And one of the interesting points on this was that the complainant tried to allege that the delay was somehow discriminatory because they hadn't done it. They hadn't terminated her immediately and had waited until she came back to work. And the tribunal actually found that that was okay because it's reasonable for an employer to wait and to accommodate a leave and to then take that action after the return. So that's just a nice one to show that it is possible to terminate immediately after a leave if you do have a non-discriminatory reason for doing so. So the second stop on our tour is termination provisions, termination cases, and I've got 3 interesting cases to highlight today. The first one is Lishuk and KJ Electric. This one, the employee was 58 years old at the time of termination. He had 34 years of employment with the same employer. He had basically only ever worked for that one employer. He was the general manager at the time of termination, and he was paid above industry compensation for that role. He also had a 20% shareholding in the company. The company decided it wanted a change of management, terminated the employee, and unfortunately for the employer, there was no termination provision limiting his entitlements, so he was entitled to reasonable notice. And when the court was discussing reasonable notice, it referred to the mythical 24-month cap on reasonable notice, and it found that that doesn't exist in Alberta. That's just a rough limit. There is no cap, and in exceptional circumstances, you can have an award of more than 24 months. They found that this was exceptional circumstances and awarded 26 months notice. They effectively found that it was a forced retirement. The second interesting point coming out of this case is that the parties both agreed that the employee hadn't taken any steps to mitigate his losses. He had not applied for any jobs whatsoever, but the court didn't reduce that 26-month notice period because it found that the employer had failed to show that there were any jobs available that the employee could have applied for if they had taken steps to mitigate. So effectively, they'd failed to show that there was a job out there for him. So that's just a reminder, really, that if you are engaged in these kinds of litigation, that you should be taking screenshots of jobs that are available on LinkedIn, Indeed, that you think they should be applying for, so that you can prove that they perhaps could have been re-employed if they had actually tried. The third point coming out of this case was relating to a bonus that was paid to employees who were also shareholders. And the employer tried to claim that that wasn't employment compensation because it was related to the shareholding rather than the employment. The court found that it was employment income and that it was payable through the reasonable notice period because there were no restrictions limiting those entitlements. Now, there was a buyback provision in the unanimous shareholders agreement, but that only referred to buyback on termination and didn't specifically speak to whether termination included the reasonable notice period. So the court found that that wasn't enough to limit those entitlements. The second case is actually quite similar. The case of Kirk and Spartan Controls. This is an Alberta Court of Appeal decision. In this case, it had been settled that the employee was entitled to 20 months reasonable notice. The question was whether the shareholder profit sharing program formed part of that reasonable notice or not. In this case, after 3 years of employment, employees could buy shares, but it wasn't mandatory. And then they would receive an annual bonus every year that was a return per share based on how well the company was doing. Everybody had to sign a unanimous shareholder agreement to participate. And there were two provisions in that USA that were relevant. The first was very similar to the one in Leeshuk that referred to a buyback right on termination. And similarly, the court found that referring to termination wasn't express enough to exclude the reasonable notice period. So if that had been the only provision, then the outcome would have been the same as in Leeshuk. It would have been employment compensation and it would have been payable. However, in Spartan, there was actually another provision in the unanimous shareholders agreement that allowed the company to buy back shares at any time, whether still employed or not, with 90 days notice. And as a result, the court found that the employee didn't have an unrestricted right to receive these profit sharing bonuses because those shares could be bought back at any time. The employee tried to argue that the exercise of that provision was not in good faith, and the court was not having any of it. The court said, no, the employer can rely on that provision. It's an express provision. There's nothing wrong with exercising that on termination. And the evidence was that they did always exercise the buyback rights on every termination, that it wasn't specifically aimed at this employee. And as a result, the court found that the employee was entitled to that bonus for the first 90 days of the reasonable notice period, but then it was gone because of that buyback right. So that's just a reminder really on drafting on these kinds of incentive plans and shareholder plans that you need to make sure that you have provisions in there that are sufficiently targeted to make sure that if there is an entitlement to reasonable notice, that entitlement will not include those profit sharing and incentive bonuses as well. The final case is Singh and Clark Builders. I won't go into the facts on this, but essentially the employer asserted just cause on termination and then decided in litigation to not assert just cause. The court found that that was fine. They could still rely on the without cause termination provision because the initial assertion of just cause was reasonable. It was in good faith. They had good reason to assert just cause. So it didn't take away their ability to rely on the without cause termination provision later, which is a positive thing. And just as a general point, we're not seeing the same level of kind of nitpicking in Alberta as you do in Ontario relating to the language of termination provisions, but we still recommend that that those are kind of reviewed because particularly Leeshuk and Kirk, those were big awards because there wasn't that enforceable termination provision included. So our third stop, and I'm conscious I don't have very much, if any, time remaining, is just a very quick update on statutory updates. There have been changes to the occupational health and safety legislation in relation to harassment and violence policy requirements. So they've kind of changed the focus from being very prescriptive as to certain statements that have to be included. Those have gone. Now it's more focused on actually including measures and procedures. So, how you're going to identify harassment and violence hazards, how you're going to inform people of that, the process for reporting harassment and violence, and how you're going to keep matters confidential. There are a couple of other small changes there in terms of when you have to review the policy. You used to have to review it every time there was an incident. Now it's only if the incident means that it's necessary to review it. And you now have a new requirement to review the policy if there's a change in the worksite that means that potential for violence or harassment has changed. And then the final piece just to mention is the statutory long-term illness and injury leave. That's increased to 27 weeks from the 1st of January. So you should make sure that your policies reflect that. And just on a non-Alberta update. I also practice Nova Scotia law, and I'd just like to flag for those of you who operate in Nova Scotia that with effect from September 1st of last year, you now have to have a harassment policy in place. The requirements are pretty similar to the other provinces, so it is possible to have like a cross-Canada version. But if you do have operations there, then you should definitely ensure that you are in compliance with those new requirements. And back over to you, Craig.
Thanks, Jen. Appreciate it. And we are over to Camille to discuss Quebec's hybrid workplace. Camille, you're up.
Thank you, Greg. So as many employers are currently reassessing their workplace strategies and maybe moving toward increasing in-office attendance, we wanted to discuss recent Quebec case law that has begun to shed light on the scope of an employer's management rights and the circumstances in which remote and hybrid work arrangement may be considered as a contractual condition of employment. So case law on the subject remains in development and is expected to evolve further in 2026, especially in the context of individual employment relationship. But today I will review the key recent decisions addressing the issue and discuss their practical implication for employers who want to increase in-office attendance. Before turning to the key decision addressing the issue, I think it's really helpful to briefly review the applicable legislative framework governing remote work. So first of all, under the Civil Code of Quebec, employers have the authority to direct and manage how work is performed. This includes the ability to establish, obviously, rules, expectation, and standards of conduct. And decision regarding where work is performed fall within these management rights. As a general principle, employers may require employees to perform their work on site and or under no obligation to offer any remote work arrangements. And in order to be enforceable and properly managed, remote work arrangement must be clearly defined, whether through individual contracts, applicable collective agreements, or policy adopted by the employer. And next slide. Turning now to a non-unionized context, the collective agreements obviously play a central role in establishing the scope of an employer's obligation with respect to remote work. So when the collective agreement contains specific provision governing remote work, the employer is required to comply with these obligations. And the same principle applies where there's an internal policy or a letter of agreement expressly requiring the employer to allow remote work or limits its ability to terminate or modify such arrangements. And in the present of these types of contractual restrictions, the employer retains its management rights with respect to work organization and the determination of the workplace. In this context, the arbitration tribunal in Quebec has recently dismissed grievances challenging an employer's decision to amend its remote directives during the pandemic because there was no restrictive language in the applicable collective agreement. Well, the first decision I would like to discuss with you present an unusual scenario. So in this decision, rather than employees objecting to a return to office requirement, the case concerned union grievance challenging the employer's decision to require remote work. So when I first saw the decision, I honestly thought that was surprising because work from home is normally viewed as a perk for employees. That being said, here the union challenged the employer's decision to impose full-time remote work during the performance of major renovation work in the company premises. And so the union argued that the measure imposed by the employer infringed the employee's right to privacy that is protected by the Quebec Charter and violated the provisions of the collective agreement requiring the employer to supply a work location compatible with the nature of the employee's duties. In addition, the union alleged that the employer had one-sidedly modified working conditions without the union's consent, which constitutes a violation of the labor code. And in response, basically, the employer relied on its management rights and also argued that the decision was necessary due to operational needs. Finally, the tribunal accepted the union's reasoning that the employer cannot one-sidedly require an employee to work from home, as doing so would contravene the employee's right to privacy. Therefore, the employer cannot impose remote work without first obtaining a collective or individual waiver of the right to privacy. And another key aspect of this decision concerned the employer's prior knowledge of the upcoming renovation. So the decision to impose remote work was not driven by an exceptional event that would, according to the employer's remote work policy, have justified requiring employee to work exclusively from home. The arbitrator also found that the decision did not constitute a change in working conditions. And so it was not in contradiction of the labor code. However, privacy and contractual rights were breached. Moving on to a non-unionized workplace, it is important to remember that the employment contract forms the basic of the relationship between the employer and the employee, subject obviously to compliance with minimum standards and applicable law. However, the Quebec Act respecting labor standards does not contain any specific provision regarding remote work. So the parties will therefore rely only on the employment agreement. And if it includes clauses regarding remote work, or if the employer has adopted a remote work policy, then the company must comply with those obligations. But in the absence of such provision, the employer retains full discretion to establish where work is performed. And to give you concrete examples, I wanted to quickly go through three recent decisions where the Administrative Labor Tribunal examined the scope of an employer's management rights in relation to remote work. So in the first case, the tribunal dismissed the employee's construction dismissal claim. So the employee was here a product development leader, and she claimed that she had been constructively dismissed when the employer required her to return to the office after 2 years of remote work. And the employer argued that she had basically abandoned her job by refusing to comply with the terms of her contract to work from the office. And the employee claimed that there was apparently an agreement or at least an understanding that she could now work remotely full time. But the evidence in that case showed that her working condition had actually always been the same, to work full time in the office. And the employer even offered a compromise here. I think the employer offered her to work like 3 days per week in the office, but she refused. And then the employer repeatedly communicated to her that she needed to come back to work in person. And the decision was that, by refusing or failing to show up to work as requested by the employee effectively decided to end her employment. So it's an implicit resignation. So she was trying to force basically the employer to accept the conditions that she wanted without any negotiation. The court also noted that the employer had been very flexible during the pandemic, but that didn't give her the right to impose permanent remote work. In the end, the tribunal concluded that, as I mentioned, she had resigned, and she brought her employment to an end by refusing to comply. And she was also fully aware of the consequences. Please note that this decision is currently under internal revision. And so the other decision that I wanted to discuss, so Gerard versus Saman Inc. Here, the employers, I think you should all be aware that to be careful, because when there's a clear remote work agreement between the employee and the company, if you one-sidedly change it, it could constitute a substantial change to working conditions, and that may amount to constructive dismissal. And that's why any modifications should be carefully communicated and negotiated with the employee. So in the Girard case, after a new owner arrived, the employee renegotiated her role to work fully remotely. So previously, she was a sales representative working on the road, and it was agreed with the new owner that she will now be a production coordinator working only from home. But 6 months after, the employer just decided to remove her access to the company's IT system and making remote work obviously impossible. And the employer then offered her two choices. The first one, to return in person or go back to her previous role. The tribunal found that this was a one-sided and substantial change to her employment contract, leading to a constructive dismissal. And so the key takeaway of this decision is that, preventing an employee from working remotely as agreed in her employment agreement is enough on its own to trigger a constructive dismissal. Finally, in the last decision that I wanted to discuss, the tribunal established that when an employee seeks to discipline an employee who refuses to return to in-person work for insubordination, the employer must still apply the principle of progressive discipline. So in the Drake decision, it's an employee who had been working remotely during the pandemic. A year later, the employer asked the employee to return to office, and the employee obviously refused, and the employer decided to immediately terminate her via email. The tribunal found that this was a wrongful dismissal because even if employers do have the right to terminate to establish where work is performed, a refusal to return to office could not here lead to an immediate disciplinary termination. Instead, here the employer should have applied progressive discipline. So what this decision shows is that immediate dismissal after a first refusal is legally risky and likely to be considered a wrongful termination. So I'll now hand it back to Greg. Thank you.
Thanks, Camille. Jeff, you are up. Great. Let's hear what's happening in BC.
Thanks very much. I'll start with a couple updates regarding the changes to the BC Employment Standards Act that happened in November. The first one was the introduction of a new job protected leave. This provision provides employees who are unable to work for at least 1 week due to serious personal illness or injury with up to 27 weeks of unpaid leave within a 52-week period. This is job protected like other leaves under the ESA, the Employment Standards Act, in that the employer can't terminate or change a condition of employment without the employee's consent because of the leave. Practically, employees already had protections as a result of human rights legislation, but given the administrative mess that is our Human Rights Tribunal, where access to remedies are years away, this new provision can be helpful to employees in these circumstances. It should be noted that employers aren't free to terminate employees after that 27-week period. It's not that there's no protections anymore after that point. There is still that duty to accommodate up to the point of undue hardship under human rights legislation. So that's one new leave. For eligibility for that, there is no current minimum amount of service to be eligible. There is a provision in the language that suggests that there could be a regulation introduced to set a minimum amount of service before becoming eligible for that, but there isn't anything at this point. But what the employee needs to do is obtain a medical certificate from a health practitioner that states that they're unable to work due to medical reasons, the date that the inability to work began or is expected to begin if there's going in for surgery or something like that, and the date on which they're expected to be able to return to work. So for those familiar with developments in BC, might be saying, I thought I heard something about not being able to ask for sick notes or doctor's notes. So that is another change that happened in British Columbia under the Employment Standards Act. And so the long personal injury and illness leave for serious reasons where it's beyond a week, that's exempt from that restriction. But what the Employment Standards Act amendment did was it restricted employers' ability to request notes from a doctor or medical practitioner in relation to the first 2 health-related absences of 5 days or less in a calendar year. So there is that restriction. It doesn't apply to those longer-term leaves. It doesn't apply to circumstances where an employer needs a doctor's note or health record to assess whether the employee is fit to return to work after a medical leave. So there are some exemptions to that. So next I'll turn to a couple cases. And so starting off with just 2 termination cases. The first one, the Max Convenience Stores case, was noteworthy because the Court of Appeal confirmed that in BC, employees on fixed-term contracts have a duty to mitigate if the contract is terminated early, unless there's an express term to the contrary. And this is different, distinguishes BC from some other jurisdictions, such as Ontario, where courts have held that employees do not have a duty to mitigate in the context of fixed-term agreements. This decision here in BC, the Max decision, it was actually made in the context of a class action proceeding related to claims by temporary foreign workers who had been recruited to work at Max, but when they arrived in Canada, the jobs either didn't exist or they weren't compliant with the terms of the contract. So there were several preliminary issues that were dealt with through a summary trial, including whether the workers had a duty to mitigate by seeking alternative employment, even though they had fixed-term contracts. So at the summary trial level, the judge accepted that there was a duty to mitigate absent a term to the contrary, but the judge found that there was an implied term that there wasn't a duty to mitigate because they were temporary foreign workers, and in order to mitigate, they would either have to have worked illegally or waited several months to get a new work permit. The Court of Appeal overturned the summary trial judge's decision on this point, ruling that to imply a term that there was no duty to mitigate was inconsistent with the express terms of the contract, which actually contemplated that there would be a possibility that the employees would have to change jobs or return home. So as a result, even though there were significant barriers to the mitigation, the court distinguished between the duty to mitigate, which was required, and the actual duty to mitigate. So this is just a good reminder that if you're going to be using fixed-term contracts, they can be risky from a damages perspective. So important to have clear termination language addressing mitigation as well. The second case the La Plume case. This was one where the employer successfully argued that the termination clause continued to bind the employee, even though it had been entered into 10 years beforehand, before termination. And the employee argued that the nature of his employment when he signed the employment agreement was entirely different than the nature of his employment at the time of termination. And so he argued the changed substratum doctrine, in that his role as junior developer when he started was so different than his role as an operations manager when he was terminated, that it couldn't have been intended to, the termination clause couldn't have been intended to apply to his employment termination 10 years later. And so he pointed to factors such as his salary had almost doubled from $42,000 to $80,000, and that his role was managerial. And the court looked at that and said the principle wouldn't apply in this case because the changes were incremental. Those salary increases were sort of annually incremental. And although he became a manager, he retained a lot of the duties that he was still doing when he first started. So while the employer was successful on this point, employers can avoid this argument by including clear terms in employment agreements that contemplate changes to terms of employment, and that will not invalidate termination clauses. That'll continue to apply unless the parties agree otherwise. And I'll turn to the next two cases. So these are two retirement cases that I thought were just worth discussing. Didn't change the law necessarily, but helpful to keep in mind in situations where somebody is contemplating retirement or resignation, especially if it's not entirely clear. So the Pringle decision involved Mr. Pringle, who was 65 years old. He had 40 years of service, a very long service employee, and he claimed that he was wrongfully terminated in 2023. He argued that although he discussed retirement with his employer, that no date had been agreed, and actually he didn't intend to retire. The employer's position was that he had retired following discussions over several years, and it was only after the fact that he changed his mind. So what the facts were that in 2021, Mr. Pringle raised the issue of retirement in his year-end review. He wrote that they should probably discuss his retirement date, as he didn't want to overstay his welcome. There were some initial discussions about retirement. Nothing formal was decided. And then in October of 2021, the parties identified a retirement date of January 31st, 2023. But they disagreed about what that date meant to each of them. Mr. Pringle said it was just a potential retirement date and there was flexibility, whereas the employer said it understood that to be his official retirement date. And to that end, it actually announced at a management retreat that Mr. Pringle would be retiring on January 31st, 2023. Mr. Pringle was there. He didn't object to that or express any concern with that announcement. There were further discussions in August of 2022, and they agreed to actually move his retirement date back to March 31st, 2023. But then he eventually said that he didn't want to retire yet, and he actually wanted to continue for another year or more. So the employer said, no, March 31st is your retirement date, and so your employment ends there. So in looking at this, making a decision, the court looked at the law, summarized the law that said that finding of a resignation or retirement requires a subjective and objective test, whether the employee intended to resign and whether the employee's words or acts objectively viewed supported a finding of resignation. And in this case, the court limited the relevance of the employee's subjective intention and concluded, based on the conflicting evidence of those informal discussions, that the employee had actually made an unequivocal and voluntary offer to retire, and that the employer had accepted that. And they looked at evidence in terms of the acceptance of the employer having put into place a transition plan to replace the employee as of that March date. And so they said that he couldn't change his mind. The retirement had been accepted, and so he wasn't wrongfully terminated. And then the last case, another retirement one, is the Gent case. And this is a retirement case that arose out of COVID. And essentially what happened in that case was a 30-year employee. He was laid off due to COVID and never called back to work. So he claimed he was wrongfully dismissed. And the employer took the position that he had retired or resigned because there was a call a few months into the layoff in May 2020, May 2020, and he allegedly said he was moving to another city with his family and he planned to retire. It was conflicting evidence again. The court made a conclusion that he likely said words to the effect of he might as well retire, but that wasn't enough for the court, in the court's view, to establish a clear and unequivocal intention to retire at that time. And so, the court said the employer really should have taken steps to clarify his intention. And if it had done so, then it was likely that he would have clarified that he didn't have an intention to resign at that time. One interesting point from this case is that in his evidence at trial was actually very clear that he did intend to retire at 65. And so when the court was assessing damages, the judge noted that if his evidence about his retirement date and intentions had been less firm about retiring at age 65, he likely would have received a significant notice period. But since his 65th birthday was only 6 months after the date the court decided that he was effectively terminated, he only got 6 months of wages in lieu of notice. So just two cases about retirement that I think are interesting, and just reiterate the importance of clear communication, ideally documenting things in writing, making sure there's clear acceptance of resignation or retirement as well. So with that, I'll turn things back to Craig as I'm out of time.
Thanks, Jeff. All right, folks, I am going to do 4 Ontario cases. It's a real potpourri, and like any potpourri, there's good parts and there's bad parts. The first one we're going to talk about is the Ontario Court of Appeals decision in Metrolinx. This actually is a judicial review from a Gord Laborski decision back in 2023. And it has to do with off-duty social media activity and just cause termination. So in this case, we had 5 bus drivers who were fired for making derogatory and sexist comments about female coworkers in a private WhatsApp chat. And these were really graphic attacks against their coworkers. In particular, one of them was, accused of having exchanged sexual favors for career advancement. And the employer only learned of the WhatsApp chat later in a different unrelated investigation. So many months after the chat had actually sort of kicked off and the comments had been made. But one of the victims of the harassing behavior had actually received screenshots at the time. Now, she chose not to file a complaint. Like many victims, she just kind of wanted it all to go away. And it was only when it came up subsequently in this unrelated investigation that the employer's investigation was launched. Now, Arbitrator Laborski actually reinstated all 5 of these bus drivers. And in doing so, he said 2 things that were, on its face, rather ridiculous. One was that because there was no complainant, because the victim didn't want to file a complaint, the employer should not have launched an investigation. So that was number 1 that was weird. The second one was he equated a WhatsApp chat group to a backyard barbecue amongst friends. And he said essentially there was no nexus between this off-duty conduct and the workplace. And the Divisional Court in 2024 and the Court of Appeal in 2025 both really just took sledgehammers to this reasoning. And they say he makes 2 fundamental errors. The first is he misunderstands what an employer's obligation is to investigate harassment in the workplace. And they say in very clear and unequivocal terms, an employer's OSHA obligations to investigate incidents of potential harassment exist even in the absence of a complaint, right? It's not unusual for a victim to be reluctant to file a complaint or to refuse to file a complaint. And an employer's obligation to take all steps to protect their workers from harassment in the workplace is a duty owed to all employees, not just to the victims. So they were very clear in saying just because you don't have a complainant or a complaint does not mean that an employer doesn't have a statutory obligation to investigate. And then the second part of it was to say, well, this false analogy of a WhatsApp chat group to a backyard barbecue amongst friends is false, and it doesn't hold any sort of granular analysis. The reality is that these were derogatory and hurtful comments, clearly sexist comments, and they did end up being circulated in the workplace. Whether the complainant wanted to come forward or not, these were comments that made their way into the workplace, and so a nexus did exist. And sort of the upshot of all of this is to say that social media does not insulate harassing behavior from investigation and potential discipline. And so this decision is quite useful. The Court of Appeal and the Divisional Court both use very strong language to enforce an employer's obligation to investigate these sorts of incidents and inject a level of accountability into social media, a place that often it is, sorely lacking. So that's the first case I wanted to talk about. The second one has to do with absenteeism and last chance agreements. So this is a real sort of boon for employers. This was a case of a guy with more than 20 years of service. He was a butcher for Cargill. And in 2021, he took one of these classic, I'm going to go on vacation, my 10 days are approved. And then he's gone for many months. And he claims that he has a work permit issue getting back into the country. The employer says essentially that he knew all along he was going to be gone longer and just didn't seek appropriate approvals. In any event, when he does come back to work, the union and the employer and the employee enter into a final notice and last chance agreement. It includes all of the language that you would hope to have in your LCAs. So, it spells out the zero tolerance standard. It has a 24-month period. It explicitly says that any unauthorized absences can lead to termination for just cause. It requires all absences, even 1 day, to require the production of a medical note in support of the absence. And it crucially says that an arbitrator cannot relieve against the penalty imposed under the LCA. So all of those elements are present in this agreement. Sure enough, this employee misses a day in June, only 2 months after, it's about a year after filing this LCA. He misses a day in June. The employer gives him a mulligan and says, this is your only miss. The next one is going to result in your termination. He misses 1 day in July. The employer says, do you have a note? A week goes by. He produces no note. They fire him for just cause. And arbitrator Martelli is the one who's tasked with applying the last chance agreement. And to his credit, he says it's been drafted very clearly. The consequences of compliance were spelled out explicitly. There was no confusion about what would happen if he was absent. And so, yes, he upholds termination for just cause based on 1 day of unexcused absence under this last chance agreement. He even goes one step farther to say that absence actually constitutes willful misconduct under the ESA, a higher standard, because he says, look, it was a choice by this individual not to get a doctor's note to explain his absence, even if it was just 1 day. He had the power to cure it. He chose not to. So not only is it just cause, but it's also willful misconduct, which means he doesn't get anything under the ESA either. So a very helpful decision for sort of road mapping what your last chance agreements should look like and giving you some teeth to enforce them when the time comes. The third case I'll be very quick on. It's about constructive dismissals and return to work. This was a terrible set of facts for this employer. They were a failing ad agency that during the pandemic went from about 50 employees down to under 10. They had just promoted to EVP, a female employee of theirs. Along with that promotion and job title, she went from $220,000 a year to $300,000 a year. She goes off on mat leave in July of 2022. And when she comes back to work in 2023, they issue her a letter that not only changes her compensation from $300,000 down to $210,000, they change her job title from executive vice president to vice president. There's a question in this case around, job protected leaves of absence and whether they were obligated to give her the exact same job back. All of that is kind of by and by because the core principle is this was a clear constructive dismissal. The employee treated it as a dismissal, and the employer had clearly made a unilateral change to a fundamental term of their employment. So a really kind of classic cut and dried case of constructive dismissal. And they went one step further by saying that the letter that was issued that demoted this employee was drafted in such a way that it lacked the kind of sensitivity that an employer otherwise should show to employees when they are making a compensation reduction. So a classic roadmap on constructive dismissal and what not to do. And the last one that I'll flag before we turn to these questions is about vaccine and COVID hangover cases. Believe it or not, these still exist. There are still cases out there that are being litigated around whether or not someone ought to have complied with a vaccination policy and what the consequences for noncompliance ought to have been. This was, again, kind of a classic case between your policy is reasonable, but was the consequence of termination proportionate to their lack of compliance with the policy? And the real rub point here is you can have a policy, but if the job itself, if the day-to-day tasks of the job are always done remotely anyways, the non-compliance with the vaccination policy probably should not have resulted in termination for just cause. Just a little reminder, these cases are still out there. They still have wonky results here and there. And if you are one of the unfortunate employers who's still dealing with some of this hangover, consult legal counsel, because the case law on this has kind of gone all over the map. And that's it for Ontario. I think there are a few questions remaining in the chat. Happy to sort of throw it open. I see that Jennifer is going to answer a question from our Alberta client about OHS changes. So Jen, jump in.
So yes, the question was regarding my last slide on the occupational health and safety changes. That slide is referring to the Alberta changes, and if you want more information on those, you can reach out directly. There's also a blog on the changes on our employment and labour law blog, which I believe the link for that is in the chat. I also mentioned at the end the changes for Nova Scotia. They're not on the blog. If you have any questions about that, then please feel free to reach out directly and I can assist.
There's also a question in the chat about, and I had answered it in writing, about the duty to mitigate. Happy to have my colleagues jump in on this one as well. I think it's sort of been interpreted as some new development. The duty has really always rested with employers to show a failure to mitigate. And really over the last 20 years, I think courts have been pretty consistent in saying it's the employer who has to lead evidence to show that there were jobs available to the employee and that the employee was qualified or that they ought to have applied for that job in question and that they failed to do so. And that's a pretty heavy onus for employers. It does require quite a bit of homework to make sure that we've done our sort of due diligence in the months following termination to make sure that when we're testing their representations and examinations for discovery, we can point to incidents or areas where maybe they were lax or maybe they didn't apply for jobs and test why they didn't do so in the circumstances. Any other comments from the team on that issue? Happy to turn it over. Oh, I see Larissa.
Yeah, I was just going to reinforce that at least in Ontario, like it's been the law since about the 1970s that it's the duty of the employer. And the leading case, which was Red Deer College, does confirm that the burden is not a light one, particularly, I think, because of the assessment that it's the employee that is the innocent party. They're the ones that whose employment ended. And so there's going to be an extra demand on the employer to prove that they, through that reasonable search would have found something quicker than they did.
Yeah, the only other part I would add to that is just, oftentimes clients are hopeful that when you establish a failure to mitigate, all of a sudden it has materially altered your potential liability. In our experience, rarely the case. Judges might give you a discount, but it is not going to be a significant discount. And many clients will say, well, is the juice worth the squeeze? If we're going to spend thousands of dollars monitoring the job market, are we going to be rewarded on the back end? Not necessarily. And unfortunately, like with most litigation, it often will turn on your luck of the draw and what judge is sitting on that bench. It is 1 o'clock. Thank you so much for attending today. If we didn't get to your question, or if you have a more specific question you would like answered, feel free to reach out to either your regular lawyer at Denton's or any of the presenters here today. Again, thank you so much for making time for us. We truly appreciate the feedback and your contributions. And we hope to see you next month at our next session. Thanks again.